Quebec versus Bombardier Incorporated, 2015 SCC 39, 2015 2 SCR 789. Javed Latif, a Pakistani-born pilot, possessed a Canadian-American license. Following his request for specialized training at the Bombardier Aerospace Training Center, the U.S. Department of Justice made Mr. Latif undergo special security screening. From the unfavorable reply from the DOJ, Mr. Latif was unable to apply to the program with his U.S. license. Later on, Mr. Latif was refused training from Bombardier in Montreal through his Canadian license, based solely on the fact that the DOJ had not issued him a security clearance. Only after several unsuccessful requests to the U.S. authorities to have his file reviewed was Mr. Latif finally granted security clearance in 2008. During that time, Mr. Latif filed a complaint with the Commission before the Human Rights Tribunal. The tribunal found that Bombardier had violated Section 10 of the Quebec Charter of Human Rights and Freedoms. Considering reports about racial profiling against Muslims, such as the Bahidi report, the tribunal found that Bombardier's denial of Mr. Latif's request had thus had the effect of creating a distinction based on prohibited grounds of discrimination, namely ethnic or national origin, which had in turn had the effect of impairing his right to a full and equal recognition and exercise of his rights guaranteed by the Charter. The tribunal ordered damages totaling over $300,000 in favor of the complainant. However, Bombardier appealed to the Quebec Court of Appeal, which set aside the tribunal's decision. As a result, the Human Rights Commission obtained leave to appeal. Issues 1. Has a plaintiff proven a prima facie case or proof of discrimination? 2. Does the previous result in Mr. Latif's case in the tribunal apply to the decision in this current case? Does the appeal hold up in court? Decision. The appeals are dismissed. Under Section 10 of the Charter, a plaintiff must establish a connection between a prohibited ground of discrimination and the complaint. While the referenced Bahidi report may have indicated systemic discrimination to national security-related programs, it did not prove that Mr. Latif's security denial was motivated by these discriminatory factors. Therefore, the plaintiff had not proven a prima facie case. This decision was made in stare decisis, reference to Riel v. Moir, 2001, RJQ 2590, and also Velk v. McGill University, 2011, QCCA 578. 2. Although the connection could have been established, and the tribunal could have ordered the Bombardier to pay Mr. Latif, the Quebec court found that this case merely contained an absence of proof. Therefore, the tribunal's decision was set aside, and the appeal did not hold up in court. The case's inability to present evidence supporting discrimination of Mr. Latif resulted in the dismissal of the appeal. Although the court acknowledged that systemic discrimination could have existed, even at Bombardier, the fact that there was no evidence meant that they could not do anything about it. This decision by the court, although justified and reasonable, is also very discouraging to other individuals who felt that they have been in the same place as Mr. Latif, because they feel like their claims and their lack of evidence won't bring them to the proper justice. In general, the tribunal can be seen as a more lenient system than other courts, like the Court of Appeals, given that the tribunal ordered Bombardier to pay Mr. Latif, the Court of Appeals set aside the tribunal's decision. As quoted in the court judgment case, this relaxation of the rules of evidence is not unique to the tribunal or to the application of the Charter. It can be found, in fact, in the enabling legislation of other quasi-judicial tribunals. In civil law cases, it is known that the complaint must be demonstrated on a balance of probabilities, in which the Human Rights Tribunal falls under, while criminal law cases are less lenient, wanting charges to be proven beyond reasonable doubt. This does make sense, because usually criminal law cases have much more heavier charges and much more serious consequences. So, the survey question here is, hypothetically, if Bombardier acted upon the DOJ, and the DOJ racially discriminated against Mr. Latif, would you regard Bombardier's incompetence to fully understand the circumstances as a form of discrimination? Thank you.